it not be said, declares Rush about his proposal to incarcerate drunkards, that confining such persons in a hospital would be an infringement upon personal liberty, incompatible with the freedom of our governments. We do not use this argument when we confine a thief in a jail. And yet, taking the aggregate evil of the greater number of drunkards than thieves into consideration and the greater evils which the influence of their immoral example and conduct introduce into society than stealing, it must be obvious that the safety and prosperity of a community will be more promoted by confining them than a common thief. Well, that was words from Benjamin Rush, the founder of modern psychiatry, of American psychiatry, and also a signer of the Declaration of Independence. Those words are actually, most of those words are actually in a book called The Manufacture of Madness by the late Thomas Szasz, which came out in 1970 and was a critique of modern psychiatry. Why are we opening with this reading? It's because it will become relevant later when we talk about a Second Amendment case and the perils of using history to figure out what was constitutional back when the Constitution was adopted. So we'll get back to Benjamin Rush and all that. But before that, we will have a different case about class actions today on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Thursday, May 2nd, 2024. And I am delighted to have on the show today, IJ's Bobbi Taylor. So Bobbi, welcome back to Short Circuit.
Thanks, Anthony.
And Bobbi is going to introduce this case from the Seventh Circuit. What's going on there? Very, very not history case about fees and extortion, basically, when it comes to class actions. So that's going to be fun. And then a little later, we'll get into the Second Amendment and the Eighth Circuit. So, Bobbi, this is kind of a Frank Easterbrook case from Judge Easterbrook from the Seventh Circuit. This is some classic stuff, class actions, Judge Easterbrook calling everything like it is, love him or hate him. He always does that. So what's going on here in this case from Chicago?
This is a racket, Anthony, as Judge Easterbrook would put it. And this is the case of Alcarez v. Acorn out of the Seventh Circuit. Now, before we get to the facts of this case, I thought it might be helpful to provide some background information on the Securities Exchange Act of 1934. Just briefly, this is an act that governs publicly traded companies and the duties that they have to their investors. Relevant to this case is a duty to disclose. So under Section 14A of the Act, whenever there's going to be a transaction involving a shareholder vote, so think a merger, a buyout, a tender offer, the company must disclose to its shareholders all material information about the proposed transaction so that the shareholders can vote in an informed way. If a company fails to disclose material information or intentionally omits it or falsifies it, the shareholders can then bring suit under the Act. And where you typically see this happen is after a merger, things go south, the shareholders lose money, and they sue as a class action on behalf of all of the shareholders, usually saying that the disclosures leading up to the merger were insufficient or false. But that's not exactly what happened here. So let's get into the facts of this case. So here in 2017, Acorn Incorporated was merging with Fresenius Kabi, and both of those are manufacturers of pharmaceuticals. So Acorn sends its shareholders an 82-page proxy statement with 144 pages of exhibits, with the recommendation that they vote to approve this proposed merger. Before the vote can even take place, very soon after the initial disclosure, actually, 6 plaintiffs file suit. And they file suit basically to compel additional disclosures. 5 of these suits are filed as class action suits. So one plaintiff is proposing to represent an entire class of shareholders. And that becomes important later. Immediately after these suits are filed, though, Acorn amends its proxy statement to add additional disclosures. They don't admit to any wrongdoing. They don't say that the initial disclosures were deficient or that they're required to do anything else by law. They just provide additional information that ends up not really affecting the shareholders at all. Immediately after these additional disclosures, the 6 plaintiffs moved to dismiss their own cases as moot because they filed to compel additional disclosures. The additional disclosures were made. They say there's nothing to sue over.
And the motion to certify the class has just been pending, so that's not
correct. And that's why the class action thing becomes important. As I mentioned, that 5 of these were filed as class actions, and typically class actions can't unilaterally be dismissed by the representative plaintiff. They have to be approved by a judge after notification to the class. But since everything happened so quickly here, there wasn't even time to get the classes certified. So the individual plaintiffs decided on their own that they were going to dismiss the suits. Very quickly after that, 6 different district judges approved the dismissals, and you would think that's it. There's nothing to be done. But not yet, because as part of this agreement to dismiss the lawsuits, Acorn agreed to pay a total of $322,500 in attorney's fees, or what Judge Easterbrook calls mootness fees, to be divided up between the counsel for the 6 plaintiffs. And even divided up, Anthony, I think that's a lot of money considering the lawsuits went away in a matter of weeks.
That sounds like a nice fee for those lawyers.
Right. And so Judge Easterbrook gives us a little bit of a history lesson, which I always appreciate. And he explains that these types of suits are actually very common. They're filed as class actions seeking to compel disclosures. And then the attorneys for the corporation and the attorneys for the plaintiffs kind of get together, agree on these additional disclosures. The additional disclosures are made, the suits are dismissed, and the attorneys collect fees. This happens before anyone moves for class certification, so the rules around judicial approval and class notification, they don't need to apply. Before 2016, most of these suits were brought in the state of Delaware because if you are suing a publicly traded company, most of them are incorporated there. But Delaware recognized this for the racket that it was, and in 2016, they did 2 things. They said, first, you can't file these suits compelling additional disclosures without some proof that the additional disclosures were deficient in some way. Either they were false or they lacked information, material information. And then second, they said that we're going to limit attorneys' fees unless the suits are meritorious. So we're going to do away with this practice of filing these suits just to get attorneys' fees. But these plaintiffs and these attorneys are undeterred. They just move to federal court where that procedural barrier doesn't exist and they can proceed with these lawsuits, and they've been doing so. And this is where Judge Easterbrook calls the scam a racket, plainly. And he candidly says all that happens here is that money gets moved from the corporations to the attorneys. The shareholders are no better off because the disclosures don't really inform them that much. And really, they're worse off because the payment of the attorney's fees diminishes the corporate treasury, which even marginally lessens the value of their shares. So now back to Acorn. A man named Ted Frank is a shareholder of Acorn, and he learns of the attorney fee payment through the press. And he's understandably upset that a company in which he chose to invest his money has paid fees for what in his mind is a frivolous lawsuit. So he files a motion to intervene, and he's asking the court to do 2 things. He's saying either order disgorgement of the money. He feels that the attorneys earned this money unjustly, or that a court should enjoin future payments for these mootness fees in the future. But the district judge says, Mr. Frank, there's nothing to intervene in. The lawsuits have been dismissed, and you can't even object to an award of attorney's fees here because it wasn't technically an award of fees. It was an agreement, a handshake, if you will, between the 2 parties that the fees were going to be paid. There was no award. So he's not allowed to intervene, but they do something interesting, and they allow him in his own appeal to participate as an amicus. And He very wisely cites this Walgreen case from the Seventh Circuit. And the Seventh Circuit's seen this before, as Judge Easterbrook points out. And so the instruction to the judges in the Seventh Circuit is when you see these cases seeking additional disclosures, immediately after filing, these cases need to be reviewed for frivolity. The district judge acknowledges that he did not do that. He reopened the dismissed suits, found them frivolous, and ordered that the attorneys return the money. So now we've got cross appeals here because at least two of the attorneys want to keep their money. And Mr. Frank wants more relief. He wants to be able to intervene. He wants to be able to make his case that these suits should be enjoined in the future. So the first issue addressed by the panel on appeal is, does Frank have standing? And they say that he does. He suffered a loss. Diversion of corporate money to the payment of these fees diminished the value of his shares, however slightly, but enough to give him standing to sue. And
seems like more standing than the original lawsuit, I have to say, which was
right.
Just, some disclosures that maybe have no effect on the value of the company.
Right. Well, not only did they have no effect, Anthony, but just a little aside here about the merger itself. The vote went through. 99% of the votes were cast before these additional disclosures were ever made. And the merger fell apart for reasons completely unrelated to this lawsuit. So the shareholders were only worse off. There's no argument that they could have been better off. And what I found interesting is here at IJ, we have to argue standing a lot. And Judge Easterbrook says even an identifiable trifle is enough for standing. And I've got clients that have suffered an identifiable trifle, and I'm still arguing about standing. So I found that very interesting. They also point out that as a shareholder, Mr. Frank would have been a member of any proposed class under these lawsuits. And when a class representative isn't looking out for the best interests of a class, it is absolutely appropriate for another class member to intervene. They said in this case, the class representatives weren't looking out for the best interests of the class because, as you point out, they were actually worse off with these disclosures. And the disclosures weren't material. They made no difference in the merger vote, and the payment diluted the shares. So the denial of Frank's motion to intervene was improper. But then the question becomes what to do on remand, because as the court explains, disgorgement of the funds is inappropriate. They've already been ordered to return the money. And the court can't grant injunctive relief in the form of barring these attorneys from making future suits like this because they're not parties to the case. So they can't be parties to any injunctive relief. There's not even any hope for relief under the Securities Act itself because the act says that any award of attorney's fees has to be reasonable. And although, as we talked about, the payment here isn't reasonable, it wasn't an award. It was a handshake agreement between the parties. So you think maybe Mr. Frank's out of luck here, but then the court wisely turns to Rule 11 of the Federal Rules of Civil Procedure. And this is the rule that obliges judges to determine whether each suit was proper at the time of filing, and obliges judges to make sure under Rule 11B that these suits are not filed needlessly to increase the cost of litigation. And as Judge Easterbrook points out, and as the district court even found when they dismissed the claims as frivolous, that's exactly why these cases were filed. They were filed to basically blackmail Acorn into paying these attorneys to go away. And even the district judge said they should have been dismissed out of hand. What the district judge did do in dismissing the cases is they didn't cite to Rule 11. They cited to their inherent authority to rectify justice. And Judge Easterbrook says, no, you don't need the inherent authority to rectify injustice. You have Rule 11B right there that says that you have the authority to dismiss the case if you feel like it was frivolously filed or done solely as a means to increase the cost of litigation. So on remand, the Seventh Circuit tells the district court, grant Frank's motion to intervene, allow him to make his argument that the lawsuits were frivolous, and presumably dismiss them again and kind of hints at maybe this time these attorneys get some sanctions. So we'll see what happens. But I found that case, pretty interesting for the admonishment that he gives. Judge Easterbrook seems to kind of give these attorneys.
And so is the bottom line that these attorneys get to keep any of these, quote, mootness fees?
No. In the district court, all of the suits were dismissed and the district judge ordered all of the money be returned. And as the court explains in the Seventh Circuit, 3 of those attorneys said, okay, we can live with that. They did not appeal.
And that was the cross appeal, was the
Right.
2 who were fighting that.
The rest of them did. They wanted to keep the money and they said, no, we're going to keep the money for the benefit of all the plaintiffs. But I question that motive a little bit. But yeah, I mean, I think that regardless of what happens on remand, these attorneys are not going to get to keep these fees.
Yeah. And rule, for non-lawyers listening, Rule 11 is never something you want to come up in your case. Usually it's kind of like waved about and you don't actually have a court grant sanctions under Rule 11, but it basically is, the rule that if Rule 11 is being waved about, it means your case is frivolous, or whatever motion you filed in the case or whatever is frivolous. And so that it is now remanded to figure this motion out under, or the case out under Rule 11 is like hit the panic button kind of moment if you're an attorney.
Yeah, and they say, we're remanding to allow Frank's motion to intervene to be granted so that he can make his case, but his case is already made for him. In
right.
the words
There's
of
no
the
fees that
judge.
are being made.
Right.
Yeah, this is kind of the coup de grace is going to be the Rule 11 stuff. So I should point out that Ted Frank is not no ordinary shareholder. He is head of the Hamilton Lincoln Law Institute and has been working for years to try to bring some more rationality to our class action system, and intervenes in a lot of these cases to make similar arguments to this. And I don't know a lot about the area, but I have to say from what I've seen that he's done, it seems mostly to the good. We actually had Ted on the show, it's a few years ago now, but I just looked it up. It's Short Circuit 154. If people want to look it up, we'll put a link in the show notes to it. But we talked there about a case that he had in the Ninth Circuit where he intervened. And there was one case that went to the Supreme Court that was, I think it was mootness, or it was some reason they didn't really rule on the substance of what he was arguing about, which was a kind of like settlements going to nonprofits, basically, and no one, who was really harmed by the lawsuit was about getting the money in the first place. A little bit like here with attorney's fees. So this is another example of Ted's work in this area. And I think he found a willing accomplice in Judge Easterbrook in the Seventh Circuit to fight as part of this. Does it seem, one thing I'm not sure, Bobbi, didn't read the case as closely as you did, it seems like this kind of practice, the specific practice of mootness thing, was basically shut down in Delaware because of what its Supreme Court did, but it is now in the federal circuit courts. It seems like Seventh Circuit has some stronger law in this regard now, but there's other circuits where this is kind of still a thing.
Yeah, to your point, Anthony, it was excuse me, it was shut down in Delaware after the 2016 case. Before the 2016 case, over 90% of these cases had been brought in Delaware. And after that, 90% of them, over 90%, were brought in federal court. So
not a coincidence.
Right. And I'm not aware of any other circuit with such strong language calling this practice a racket as the Seventh Circuit. And I think it's important to note that Judge Easterbrook didn't have to make this up himself, even though he agreed with it. He followed a precedent case. So theoretically, bringing this case in the Seventh Circuit was kind of a strategic mistake. I wonder if they could have avoided that. But yeah, I mean, I think that the Seventh Circuit has some pretty strong language here against bringing these types of frivolous cases.
And before we leave this case, we should do, for the benefit of plaintiffs' lawyers listening or others who maybe have a different take on this kind of litigation, I think the argument for this type of lawsuit, I mean, it's not this particular one, but this type of lawsuit, is that public companies need to give certain information to their shareholders. It's not just a matter of federal securities law if you don't like that, but just a matter of common law fraud, that they have a contract with their shareholders. They should give all this information, and it's better to have that information because although, most of us own stock and don't even know about it, like if it's in our 401k or whatever, there are investors out there who watch this kind of thing. And when they find those nuggets in these corporate reports, it will then, sunshine is the best disinfectant, and the news will get out, and that will then make the company do better practices. And so essentially, I guess what's wrong with that? Is it that this is just over the top disclosure that these lawsuits are generally about? And so they're not, you said it was, after 99% of people had voted anyway, or, is there something to that argument that some more disclosure often, is a good idea? And so these lawsuits aren't entirely frivolous.
I don't think there's anything wrong with mandating disclosures. And I don't think there's anything wrong with filing lawsuits to mandate disclosures. I think that the Seventh Circuit has it right, though, that if you see a case like this, maybe you review it right away, just to make sure that everything's on the up and up and that this isn't what we have here, which is pretty plainly a racket to get attorney's fees. I don't think every case compelling additional disclosures is that. I think that there's a lot of good reasons for why investors would want more information from the publicly traded companies. And I don't think we should discourage these meritorious suits from coming forward. But by clogging the docket with these frivolous ones, we're hurting that process.
Gotcha. Well, I'm sure we will talk about attorney's fees and class actions and later short circuits. And we often cover them on the Short Circuit newsletter that if you're not subscribed to, you can check out at shortcircuit.org. You can then sign up for the weekly newsletter that will come into your inbox every Friday. But now we're going to move to something else that we cover on the newsletter, which is the Second Amendment and guns. So first, we'll set up the story behind this case from the Eighth Circuit. And then we will get into some of that history that I opened with. So the case is United States versus Veasley. Devontae Veasley is the defendant. So it is a federal criminal prosecution. And it was issued on April 17th of this spring. It's an opinion by Judge Strauss, which he was a good writer, and they're always interesting. He's a Thomas clerk and a big-time originalist. So this is a big-time originalist case. And there's also a concurrence that we'll get to at the end. So this guy, Devontae Veasley, here's the fact. The facts are two sentences. This is not a case about facts. This is how Judge Strauss puts it. A drug deal went sideways when, rather than going through with it, Veasley pulled out a handgun and shot at his dealer. Now it says at his dealer, so I don't think he hit the dealer. I don't think anyone was, killed here, wounded. But anyway, he shot at his dealer. After the attack, the government charged him with possessing a firearm while, quote, unlawfully using a, quote, controlled substance. So before we get into the law and the Second Amendment and Constitution and all that, I just have a first question, which isn't in the case, which is this guy just shot at somebody as part of a drug deal. And yet he's in federal court being prosecuted for possessing a gun while being on drugs, basically. We're not told what the drugs are. I would hope that in most cases, a person like this would be shot for, attempted murder or, assaults, or if he did have drugs on him for drug possession, although I'm not a big fan of that kind of prosecution. But no, he's in federal court, and that would be in state court usually. He's in federal court with this weird law that now we're going to talk about. So that just kind of shows things are screwed up in our criminal justice system, which everyone already knows. But I think that's an example of, federal crime being out of control and all that. I'm guessing what happened is it's a lot easier to prove this case than it would be for the attempted murder or assault, because then you have to have all the witnesses and go to a jury and icky stuff like that. And here you can just threaten him with an obvious crime.
It's also a plea.
Yes.
Which is much easier to there's a reason why a lot of federal cases plead out.
Exactly. And I will get to that in a moment. But yeah, this didn't go to a jury. And I think it's because he saw the writing was on the wall. I mean, if the facts are true, the two sentences of facts, he was on drugs in some way, inarguably, maybe not at the moment he shot the gun, but he had been using illegal drugs, and he was in possession, not even own, he possessed firearm. And so he's guilty of this crime. And so this is the best route that he had. So there's an indictment. It's just one count. They didn't even try anything else. They just tried this one crime. So what is the underlying law? The underlying law is in the U.S. Code 18 U.S.C. 922 G3, and it makes it unlawful. Anyone who is an unlawful user of or addicted to any controlled substance cannot possess a firearm or ammunition. So that is super broad language, right? Controlled substance, it wouldn't include alcohol, but anything that's a controlled substance under federal law, which would, of course, even today is marijuana, is all kinds of other drugs. And what's an unlawful user? Does that mean you use it every day, every month? Well, who knows, but it's interpreted, as you might imagine, quite broadly. So there's no question it applies to this guy. Now, Judge Strauss says it would also apply to, say, a grandmother who is smoking marijuana to relieve pain and, under a doctor's prescription. So it's anyone from the grandma to this guy shooting his drug dealer. And Judge Strauss says, we'll get to this in a moment when I get the Second Amendment, but that grandma could make an as-applied constitutional challenge to the prosecution. And as we'll see, she might win that. But this guy didn't have that option. So he's making a facial challenge to the law. He's saying this law on its face, which as it works in federal court, a whole different story whether it should, but as it works in federal court, that means he has to show that this law is always unconstitutional so he pleads out, as Bobbi said. Just after he pleads, the case Bruin comes down. Now, Bruin is the case from New York that went to the Supreme Court a couple years ago that really upended Second Amendment law and said that the onus is on the government to show that a firearms law is constitutional, and it has to be analogized to a firearms laws that were in place at the time the Second Amendment was adopted, or maybe if it's a state law when the 14th Amendment was adopted after the Civil War, but this is actually a federal law. So we really are talking about 1791 when the Bill of Rights was adopted, was this kind of law that was around. Okay, so the kind of law we're talking about here is you can't have a gun because you use an illegal substance or you abuse some kind of substance. So we then get a deep dive into what the laws were at the founding about, essentially mostly drunkards having guns. Something I've never read much about before, but it's pretty fascinating. And I think Judge Strauss does a really good and detailed look at this. I mean, it's not that long, but he has a lot of sources, and he points out stuff we all know. He says people have abused substances for thousands of years. He quotes this source about Persian history and how drunkardness has been a problem. He says, I didn't even know this, that they've now dated back 20,000 years where people have fermented grain into beer. So even hunter-gatherer times, I guess they had some booze. So he also talks about opium, right? Opium was a problem at times at the founding. It was known. And of course, cannabis was around, right? George Washington grew hemp. We've all seen the stamp on the dollar bill. People smoked it too. So drugs have been around. Alcohol's been around for a long time. Okay, well, what were regulations like at that time? And he says that there was regulation of controlled substances. Of course, there were restrictions on, when you could sell it, when you could use it. If you were a drunkard, you could be locked up, for example. But there was nothing specific about guns and controlled substances. So there was no example you could find from that time of a law that says, right, if you are a habitual drunkard, you can't have firearms. It would be, if you're a habitual drunkard, you can be shut away, you can be fined, whatever. There's even less with other substances, I think probably because it wasn't as much of a problem back then. But it just wasn't a thing. So he says, we can't find evidence of that. And therefore, under the test from Bruin, which is really looking at the history of firearms regulation, it's not a typical kind of originalist analysis where you're saying, well, what is the right? It's a way of interpreting that by looking through the case Heller from 2008 that many listeners know about. It's looking at what is the history of that type of regulation. And we can get into a moment whether that's a good way to analyze the Second Amendment. But if you're going to do that, hey, there's nothing here. So you're thinking this guy's going to get off because this law is unconstitutional. But wait, he then says, well, Bruin does say you can't be too literal about analogies. And you when something is, quote, unprecedented, you have to look elsewhere a little bit. Well, he also says, modern synthetic drugs, which I think is a hint as to maybe what this fellow was on, like PCP, are different than your run-of-the-mill drunkard or opium addict at the time of the founding. And these people can be really dangerous, right? When they're hopped up on PCP. You don't want them to have guns. And so what can we analogize to that? And he says, aha, and this is when we get back to Benjamin Rush, the mentally ill. So how were the mentally ill, as we would call them today, treated at the time of the founding? And he says there was all kinds of, as you might imagine, in almost any modern society, there were laws about the mentally ill. So if someone was a danger to themselves, they could be locked up. If someone had gone into mental illness and then came out again, they could be treated. I mean, he doesn't mention this, but I think a lot of us probably know the story of King George III, who went in and out of mental illness not long after the American Revolution. In fact, just a couple of years before the Bill of Rights was adopted, he was mad for several months and was locked up. And then he came back and they let him out again. And then a few years later, he kind of had the last 10 years of his life, basically, he was locked up and mentally ill. So this was a thing at the time. And he says that when people would have, especially temporary insanity, they could have their firearms taken away. So we don't have the analogy with with drugs, but we do have the analogy with mental illness. And because some people who are on drugs these days kind of seem like they're mentally ill, like hopped up on PCP, whatever, then there are some people out there who you could constitutionally take away their guns. And because this is a facial challenge, you need to show that this law would always be unconstitutional. It's constitutional. It doesn't exactly matter whether in this instance, this defendant, Beasley, would be constitutionally put away. It's kind of hinted he was on something like PCP. We don't really know, but it might be constitutional. And so therefore the law survives and he has to serve his sentence. Now, by the way, I looked at the district court. I think it was 100-something months he was sentenced to. Now, here's my problem with this. So Judge Strauss, we can argue about Bruin in the first place, which is really what I'm critiquing here. I think Judge Strauss does his best to go into Bruin. But I think the mentally ill section of his opinion has a lot to be desired, although it is very well resourced. And I was hinting at that with that opening from Thomas Saz's book, The Manufacture of Madness. So there's a couple quotations of here from Benjamin Rush. And he wrote a number of books and articles at the time about mental illness. And he's kind of the godfather of in America, about how we think of mental illness today. Now, I am not a psychiatrist. I'm not an expert in this field. I just know a little bit about it, some of which is through Thomas Saz's work. But, although he's a celebrated signer of the Declaration of Independence, he did a lot of stuff that today we would think was pretty illiberal, right? And we probably wouldn't do today to most of the people who are mentally ill. And one he's quoted as saying that when you have a temporary fit of madness, you can be locked up, essentially. Now, Judge Strauss also quotes a lot of other people. He quotes Thomas Cooley, which is interesting, though, because Cooley and a few of these other sources are writing much later. Cooley wrote basically around the time of Reconstruction, which might be great if this is a state law, 14th Amendment, but it's not. We're talking about 1791. So there's a little bit of, showing the malleability of some of this analysis. If you're not, it's not really strictly originalism at that point. But Benjamin Rush himself, the quote I had at the beginning of the show about how mental illness should be analogized to being a thief, or drunkardness, I should say, should be analogized to being a thief. That's how Rush thought about all kinds of things. All kinds of criminality was basically a disease. And so you could treat that by locking people up. Really expansive stuff that for its time was not how people thought about, how you address social problems. That kind of came later, especially with the progressive movement. And yet Rush is cited here as how things were in 1791. And it's not even so much the law, it's just kind of how he thought about addressing these problems, which it's not a big deal, right? It's just one citation, but it does show that when we're trying to do this analysis that Bruin asked for, where you have to look at like what the laws were and maybe how things were considered at that time, there's a lot of ability to cherry pick and even, misunderstand how people thought about something at one time or another, or who you need to be reading, especially when we're talking about someone like Benjamin Rush, who, although he's a signer of the Declaration of Independence, had a lot of these writings that today we would really object to and weren't even widely shared at that time. So enough with Benjamin Rush, but I think that the analysis that we have here in the Eighth Circuit it's interesting. It's I think it is kind of what Bruin was looking for, but I think it shows the limits, because we're not talking about like the original meaning of the words of the Second Amendment, like hardcore originalism or a construction on top of that meaning. We are just talking about how a shortcut to doing that is what laws there were at the time and whether or not this is analogous to that kind of law, which is a whole different thing than interpreting the text. It's just kind of like saying, well, it was good enough back then, and so it must be good enough today. But that's a whole critique of Bruin that we don't have to go down that rabbit hole today. I will finally stop talking and finish by saying there's a concurrence, very short concurrence by Judge Grunder, and he says, there was precedent in the circuit about this issue, and I think we should just follow that, and all this history stuff is pretty unnecessary. I don't know if he's quite right on that, on the cases. They're about facial challenge in the post-Bruin era. I think Judge Strauss is actually right that this guy should have been able to bring this facial challenge. But anyway, you can see there's some disagreement there as well.
I think this is a pretty straightforward application of what Bruin asks. And I also think it's interesting that this is discussing how mental illness was viewed in the 18th century, not today. Because I think if I'm correct, this idea that a mental illness is a temporary fit of madness and can be eradicated by locking someone up and taking away their guns, but that implies that it somehow goes away at some point, like drug use or being drunk. That's not how society views mental illness today. So I do think it's an interesting application. I just don't know that it's quite right, even though it does exactly what Bruin asks for. I also think that this might not have been the most sympathetic plaintiff. So, I mean, defendant, sorry. Case, so yeah. Defendant. Yeah. So you've got someone who I think, I mean, I'm pretty I'm pretty liberal in applying the Second Amendment, but I also recognize that it has limits, right? And I think this guy's on the outer limit. And I think this was Judge Strauss's way of maybe trying to fit the result into the Bruin analysis.
Yeah, absolutely. Because I think any fair reading of the two sections, the drug section, which I'm sure there are people who disagree with that, and would say that even under that this law is constitutional on its face, that the danger that everyone knows about, the Rahimi case at the Supreme Court. And for those who don't remember, Rahimi is the case where the Fifth Circuit found that the domestic violent, the federal law about not possessing a firearm if you have a domestic violence restraining order on you is unconstitutional. And then that went to the Supreme Court. Now we're still pending. The case can come out any day, but it looks like the Supreme Court, for more argument, is going to uphold the law. And if this law about drugs went up to the Supreme Court, I think it would be a similar thing. So maybe he's, they don't want that trouble down the road. So Judge Strauss says, well, let's go to mental illness here. You can argue about the practicality of that or not. But when you're going to do that, the history might leave something to be desired. And it just shows that this is a very complicated method that the Supreme Court is asking the lower courts to do. And as some listeners know, I'm a big fan of the originalist method and interpreting text, but I don't think this really is originalism. I think this is just thinking the past was, the Second Amendment was supposed to freeze the past, and therefore this is how you interpret the Second Amendment. The constitutions aren't like that. Constitutions are revolutionary documents that maybe they would find things unconstitutional from back then. Maybe they'd leave a lot of room for the future, but I don't think that's how we interpret the meaning. But anyway, this shows that doesn't mean that it can't be hard, but this shows that the path the Supreme Court has asked for is a really hard one.
I think it's interesting, too, because you'd never ask for the First Amendment to be frozen in time. Your emails have just as much protection as your spoken or written word.
Right. And in some ways, the Supreme Court's recognized that, it's not only flint pistols and muskets that are protected by the Second Amendment for good reason. And so they say firearms in common use is what Heller said. And that kind of makes sense. And First Amendment too. But yeah, First Amendment, we don't look at laws from 1791 that, were about censorship or what have you. And I'm glad we don't do that. Because
thank goodness. Yeah.
Yeah. The principles that matter. Well, Bobbi, thank you. This has been a great class action, mootness, and guns episode. So stick with us, listeners, for episodes about similar matters or different ones in the future. But in the meantime, I hope that all of you get engaged.